unless the parties, one or either or both, believe that there's a good reason this case should not be broadcast, the court will begin that process. To anyone who may be watching this hearing on YouTube, recording or rebroadcasting of this hearing in any shape, form, or fashion is expressly prohibited. Violation of the court's order in with this regard is punishable by civil and/or criminal contempt. All right, we were addressing the issue of personal service on the respondent.
I think, Judge, I don't know if I can say something. I think that y'all tried to serve him at one time, but he was in rehab down in Pasadena.
Okay.
I don't know.
Correct. That's correct, Your Honor. I'm trying to find where on JCMS it says that he was served, but he should have been served either on the new petition either yesterday or 2 days ago.
I got papers yesterday.
So I don't know if it's made its way back to the district attorney, to the district clerk's office, but if I can have a few minutes, I can go verify that.
Do you mind doing that? Because
Okay.
I don't want the court to operate without jurisdiction.
Okay,
Right.
thank you.
Mr. Holland, I appreciate you being forthcoming on this issue.
Yes, sir. I got papers.
Well, we have to make sure they're the exact right papers.
Oh, okay, yes, sir.
You don't have those papers in front of you, do you?
No, sir. I left them back.
Okay. Do you remember what they said?
It was possession of it was either possession of a controlled substance, 1 to 4 grams, or it was either manufacturing, delivering a controlled substance 1 to 4 grams.
And it was a document that was accusing you of those offenses?
Yes, I'm pretty sure.
Okay. And for purposes of the record, is the state proceeding on the entirety of the petition filed November 22nd in cause number 112450?
Yes, Your Honor.
All right. Is that your understanding, Ms. Craven?
Yes, Your Honor.
And we are not proceeding on the companion case. Is that correct?
That's correct.
Yes,
Is that
Your
also
Honor.
your understanding, Ms. Craven?
Yes, sir.
All right. And while we're waiting on Ms. Rojas, Ms. Craven, I have before me a document titled State's Disclosure of Documents, Items, and Information Provided to the Respondent. Are you satisfied with the discovery provided by the state in this case?
Yes, Your Honor. I've been able to receive documents for over the course of several months now, so I appreciate that I have everything necessary to advise my client and also to go forward with the hearing today.
And that will be received and admitted into the court's file. Because I have a waiver of 2 days signed by counsel, I'll go ahead and approve that now. But conditionally under the assumption that the court has jurisdiction, or will shortly.
Your Honor, while we're waiting on that petition, 1111-112450, I'd like to make a trial amendment.
Wait. I've got 3 people talking to me at once. Let's let Ms. Rojas, she just walked in the door. Thank you, Ms. Rojas. All right. Awesome. All right. That doesn't matter. This is the one we need. Thank you. All right. Sorry about that, Ms. Craven. We have service. All right. Yes, Ms. Craven, trial amendment.
On the full name of the respondent, the middle name is misspelled, but it looks like just a reversal of C and H in the name Mitchell.
Yes?
Just for the court's record, that's an error in the document that we can repair.
All right. Ms. Smith, I have a motion on behalf of the respondent to amend the original petition to correct the spelling of the respondent's middle name from Mitchcell to Mitchell. What says the state?
The state's in agreement with that.
All right. Ms. Craven, because this is your motion, I will grant it. And because it is also your motion, I assume is no surprise or otherwise dilatory tactic by the state. And so the court will not consider any request for additional time to prepare. And the court will approve that trial amendment by marking on the original petition to correct that middle name.
Thank you.
I see it twice on the first page. I see it once on the second page. Okay, is that it? Anybody see anything else?
No, Your Honor. Thank you.
All right. Thank you for catching that, Ms. Craven. All right, Mr. Holland.
Yes, sir.
You have an absolute right to have this hearing in front of Judge Kim. However, if you'd like to proceed today, you may proceed in front of me. Which would you prefer?
Proceed in front of you.
All right. And I already have a signed document showing counsel's agreement to that. So that will be approved. Next, Mr. Holland, you have an absolute right to a jury trial in this case. And that would be where a group of citizens from the community would be called into court. 12 of them would be selected to determine whether or not you actually did what the state has accused you of doing. As part of a jury trial, you could force the state to call in all the witnesses who might testify against you. You would get to look them in the eyes. And then your lawyer would get to cross-examine those witnesses to make sure that the state's witnesses are telling the truth. At the end of the jury trial, the jury, not the judge, but the jury would determine whether or not you actually did what the state has accused you of doing. However, you also have the absolute right to give up your right to a jury trial instead and have me determine everything. Which would you prefer to do?
You determine.
Okay. And Ms. Craven, I note that you have already signed a waiver of jury trial. Do you join that request of your counsel, of your client?
Yes, Your Honor.
All right. Now, Mr. Holland, you also have the absolute right, and we've discussed this before, to remain silent, not say anything at all. The prosecutor cannot force you to take the witness stand. And the prosecutor cannot force you to testify under oath about this case. The only one who gets to make that decision is you. Not even your lawyer can make you do that on the stand. Only you can give up your right to remain silent. Now, in a little bit, I'm going to ask you some questions. And those questions are going to be geared to asking you whether or not you admit to doing what the state has accused you of doing. If you answer those questions affirmatively, you understand that you're giving up your Fifth Amendment right to remain silent. Do you understand that?
Yes, sir.
All right. You're a pretty sophisticated kid, so I think you understand what you're doing.
Yes, sir.
But if at any time you don't feel comfortable or you don't understand what we're doing, wave your hand like this.
Yes, sir.
I'll create that internet chat room for you and your attorney to talk about it, okay?
Yes, sir.
All right. Mr. Holland, next two questions I have to ask of every kid who sits in that chair. Are you an American citizen?
Yes, sir.
Where were you born?
Texas.
Where in Texas?
Grapevine, Texas.
Okay. Now, I have before me a 2-page document.
Yes, sir.
On that second page, you'll see that your attorney has already signed it.
Yes, sir.
And there's a place, actually, she signed it there. She also signed it on your behalf, but I have to go over the entire document with you
Yes,
to
sir.
make sure you agree with it, okay?
Yes, sir.
I'm going to go over it paragraph by paragraph. And at the end of each paragraph, I'll ask you if you agree with it or if what's stated in that paragraph is true or not true, okay?
Yes, sir.
All right. First paragraph, may it be agreed and stipulated between the parties in the above styled and numbered cause in which Riley, Mitchell, Holland, Stallings has responded to the following facts. Second paragraph, if the witness, Ashley Holland, were in court and testified under oath, she would testify that they reside at, I'm not going to read the street number, but you know the house you live in,
Yes, sir.
Knox Road in Keller,
Yes,
Tarrant
sir.
County, Texas. Ashley Holland would further testify that she is the parent of the respondent in this cause, that the respondent's name is Riley Mitchell Holland Stallings, that he is a male child, 16 years of age, having been born on, and I'm not going to read your date of birth again, but it's the same date of birth we discussed earlier.
Yes, sir.
The witness would also testify that she is the person who has the custody and control of the respondent in this case. All right. Do you agree or disagree with that paragraph?
I agree.
All right. Next paragraph. I, Riley Mitchell Holland Stallings, the respondent in the above entitled and numbered cause, in writing in an open court, consent to the stipulation of evidence in this case, and in so doing expressly waive the appearance, confrontation, and cross-examination of witnesses, the right to a trial, and the right to a trial by jury, and further consent to the introduction of testimony by affidavits, written statements of witnesses, and other documentary evidence. Accordingly, having waived my federal and state constitutional rights against self-incrimination, and after having been sworn upon oath, I judicially confess to the following facts and agree and stipulate that the facts are true and correct and constitute the evidence in this case. All right. You understand that if we go further at the end of this, you're essentially going to give up your right to force the state to call its witnesses. You're giving up your right to a trial by jury. You're agreeing to let all sorts of documentary evidence come in your case. And you're giving up your right to self-incrimination. Do you understand that?
Yes, sir.
All right. Do you agree or disagree?
Agree.
All right. First fact. I was born on that date we discussed earlier, and I live in Tarrant County, Texas. Is that true or not true?
True.
All right. Now, this is the most important thing. The next paragraphs 2 and 3, I'm going to read together. On or about the 12th day of July, 2019 in Tarrant County, Texas, I did intentionally or knowingly possess a controlled substance, namely tetrahydrocannabinol, other than marijuana, of more than 4 grams, but less than 400 grams, including any adulterants or dilutants. Such conduct is a third-degree felony and violates a penal law of the state of Texas, punishable by imprisonment or confinement in jail. To wit, Section 481.116 of the Texas Health and Safety Code, and is defined as delinquent conduct as defined by Section 5103 of the Texas Family Code. All right. Essentially, the state has charged you with possessing THC other than marijuana in an amount greater than 4 grams, but less than 400 grams. Is that allegation true or not true?
True.
Has anybody forced you to come in here today and plead true to that?
No, sir.
You feel like the prosecutor tricked you into doing it?
No, sir.
Did President Trump call you on the phone last night back in detention and promise you a presidential pardon and $1 million if you just go in there and plead true in front of Judge Porter?
No, sir.
All right. Are you telling me the only reasons you're pleading true are 1, because it is in fact true, and 2, because that's what you want to do?
Yes, sir.
All right. Finally, final paragraph. I, Riley Mitchell Holland Stallings, further agree and stipulate that I am a child in need of rehabilitation or that the protection of the public requires that disposition be made. I further agree to a disposition of probation until my 18th birthday. Participation and completion of TYRC residential treatment, to follow up with any aftercare as ordered by the court or my probation officer, to submit to random UAs, to possess no weapons, including real or fake guns, and all additional conditions included in Exhibit A and any other reasonable conditions imposed by the court. You gonna be willing to do that?
Yes, sir.
All right. Couple of final things. If there is an agreement between you and the prosecutor, and if I follow that agreement regarding how this case should end up, you give up one more very important right. That's the right of appeal. That's where the Second Court of Appeals, located in downtown Fort Worth, would look at what we do here today to make sure everything was done correctly. But if I follow the plea agreement between you and your attorney and the prosecutor, you won't have any appeal. Do you understand that?
Yes, sir.
Okay. I'm going to give you one last chance to back out, or we will go forward if that's what you want to do.
We can go forward.
All right. Does either side believe there are any additional admonishments that need to be given at this time?
No, Your Honor.
No, Your Honor.
All right. Mr. Holland, based on the evidence before me, based on our interactions, not just today, but at the past detention hearings, I find that you are competent to proceed today. I further find that the allegations in the state's petition filed in this case to be true, that you did engage in delinquent conduct as alleged, and so that will be the order of the court. We are back on the record in cause number 323-112450-19 in the matter of Riley Mitchell Holland Stallings. The court takes judicial notice of the contents of the court's file pursuant to Rule 201 of the Texas Rules of Evidence, as well as all other hearings over which the court has personally previously presided. We're here for a disposition hearing. Are all sides ready to proceed?
It's ready.
Your Honor, I have a point of clarification. We're also on cause number 113304, correct? That was part of the disposition, part of the adjudication, and will be part of the disposition.
It's my understanding the state was proceeding only on 450.
That means the other's dismissed. I just want to be sure I'm clear.
That's correct.
Okay.
It has not been dismissed yet. The state has not submitted a motion to dismiss, but it's based on the prosecutor's professional statement to the court and to opposing counsel that she intends to file a motion to dismiss. Upon receipt, the court will approve that.
Thank you. And we're ready to proceed with the disposition. Respondent's ready.
Ms. Smith, what's up?
State would offer petitioner's exhibit number 1, the social history.
I've had more than 2 days to review that document, and I will allow it to be admitted. No objection.
All right. Are you aware of any additions, corrections, or deletions that need to be made thereto?
No, Your Honor.
All right. Petitioner's exhibit 1 will be received and admitted into evidence. Who would the state call as its first witness?
State would call Maria Rojas.
All right. Ms. Rojas, if you'll please raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may proceed.
Ms. Rojas, how are you employed?
I'm a juvenile probation officer in Tarrant County.
And are you the person who put together petitioner's exhibit number 1, the social history?
Yes.
And the respondent, Riley Mitchell Holland Stallings, is he your client?
Yes.
Okay. Other than the 2 offenses that he has been referred for, is this the first time that he's been referred for any criminal offense to the department? Okay. What overall his history has been primarily with drugs, is that correct?
Yes.
Can you give the court a little bit of an overview of everything that's kind of been going on regarding that since he's been in custody?
He was referred in, I believe, back in July of 2019 for the possession offense. He went to drug treatment. He came in for intake with Officer Ortiz. They had an intake appointment. All the information was gathered. The case was referred over to the district attorney's office. And again, he was referred for the manufacturing of delivery offense. He was placed or taken to JPS by mom due to suicidal threats. And then from there, mom took him to a drug rehabilitation center where he was there for 90 days. When he was released, a mom called frustrated because he went back to the drug use and then also the sale of narcotics. Mom has indicated that Riley lives with his grandparents, and so he was not respecting rules at home, even when he wanted, would continue to be involved in the sale of narcotics. And she indicated to our department that she had video footage of that activity.
Objection.
Overruled.
She was worried about his safety and the safety of others in the community, and she just was requesting for assistance. We submitted a progress report, and he was picked up on a directive issued by the court, and he's been in our juvenile detention center since.
Okay. So he has previously been to different rehabilitation centers.
He has been to one.
Okay. And how did that go? Did he complete it?
He completed it successfully. He was there 90 days.
And did he follow up in any aftercare?
No.
Okay. Who is he currently living with?
He lives with his grandparents at his grandparents' address, the maternal grandparents.
Okay. And is it your understanding that the maternal grandparents do wish him to come back into the community or to have another term of rehab?
Well, I've been in contact just with mom since she's the parent. And so she would like him to go to drug treatment. And so she was requesting assistance with that. She has been in contact with the campus and she has completed the paperwork for admission. And if he is put on supervision today, he will start that program today. They are making transportation arrangements for him to get picked up from the juvenile detention center as soon as court is over.
Okay. So do you think that it is in his best interest to be placed on probation?
Yes.
And do you think it is in his best interest to be ordered to go to the campus for an inpatient residential treatment?
Yes, it is.
Okay. And
Uh-oh. We suddenly lost Ms. Smith's internet connection. We'll give her just a minute. Okay. Okay. Give me just a second. I'm going to allow Ms. Smith to use the attorney computer, but I have to go to my chambers.
Sorry.
Unless Ms. Smith wants to object.
Sorry.
I feel like you have a GoPro on. It looks like.
All right, give me just a second to get all plugged in. All right, Ms. Smith, where were you?
Okay, I think I was asking, do you think that it is in the respondent's best interest to be placed at TYRC?
Yes.
Okay, and would you ask this court to keep him detained until he can be transported directly to TYRC?
Yes, that's correct.
Okay. With that, I will pass the witness.
All right, Ms. Craven.
Mr. Rojas, what other things is it a probation department requesting for probation terms for this juvenile?
That's the only thing for now. It's my understanding that they're going to, the campus is also going to be providing some counseling where they're going to have mom participate. And then they made some, there was some conversation about maybe having dad participate if that was permissible.
Right. And what term of probation are you recommending to the court?
Probation up to his 18th birthday it's my understanding that the state has offered.
Ms. Ross, have you discussed the educational desires and levels of this respondent with his mother and with him?
No.
Okay. Pass the witness.
Redirect, Ms. Smith.
I have no further questions.
All right. May this witness be finally excused by both sides.
By the state.
By the respondent, yes.
All right. Ms. Rojas, you may remain, but you're no longer subject to the rules of the witnesses. And who would the state call as its next witness?
The state would rest its case.
All right, Ms. Craven.
Your Honor, I'd like to call Ms. Ashley Holland.
All right. Give me just a second, Ms. Holland.
Okay.
All right, Ms. Holland, if you'll please look at the camera.
Okay.
Raise your right hand. Oh, hold on.
What happened?
I'm looking at I'm looking at the wrong screen. There we go. You solemnly swear or affirm the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, Ms. Craven, you may proceed.
Thank you, Your Honor. Ms. Holland, what is the desired educational goal for your son?
I would like him to get his GED. I don't know if the judge or probation can, I guess, put that somewhere in his probation terms.
And that's it, instead of going to a formal school or a high school, correct?
Yes, because he is so far behind right now. I feel like the GED is his only hope to get him graduated. And he has been working on that during his stay at Unlimited Visions. And that was our plan when he came back. But with COVID, that kind of put a wrench in our plan.
All right. You understand as a term of probation, he is to participate in schooling, and you're asking the court to make an exception to formal enrollment to school, but to participate in a formal GED program instead, or some form of GED program with TYRC, or after that with the junior college or someone, correct?
Mm-hmm. Yes, ma'am, if at all
All
possible.
right. And what after the youth recovery campus program, where would the respondent reside? With his grandmother or with you, or do you know?
I would prefer him to be with me.
Mhm.
He has more, what's the word I'm looking for? He has more discipline if he's with me.
All right. And you understand if he resides with you that you would be responsible to report any violations of his terms of probation, even though you're his mother, and that would be perhaps difficult to do, correct?
Oh, well, it's not difficult for me to do that. No.
Okay.
I mean, I turned him in this is both times, so.
Okay.
I just want to ensure that maybe when he gets out of this rehab program, I don't know if there's a possible way that he could have an ankle monitor or some kind of something to hold him accountable after he gets out, so that he doesn't fall back into the same patterns as far as going out with his friends, and maybe that can eliminate some of that, knowing that he's going to be monitored.
And are you willing to participate and make sure he is able to participate in any aftercare program that's required by the TYRC?
Yes, and I would like to, I heard that there's a mentorship program. I don't know if that's possible for him since his dad is not active in his life. I didn't know if there's like a big brother, or I don't know what it's called, like a mentorship program yet. That's the only thing I can think of that can maybe give him some guidance.
Do you believe that any treatment at home, like mental health counseling, through the family partnership or something like that, would be necessary, or something the court should consider at this time, or maybe perhaps in the future?
Maybe in the future. I think that it'll be good once we have some help in his rehab facility that he's going to TYRC. If they have some family counseling that maybe will help us to be on the same page when he gets out. That can help me guide me as a parent so that we can get along better.
Is it your, I'm sorry, go ahead.
No, that's it.
Is it your plan as a parent to help him be successful, to rehabilitate himself and become an active member of the society following the loss?
For sure. This was my last chance to help him. And as much as I hated to turn him in, I knew that that was the best thing for him.
Okay, so
he's about to be 17 and there's nothing else that I can do to help him.
what's your understanding of what happens when he turns 17?
He'll be tried as an adult and there's, he'll be out there with the big boys then.
Okay. So you're stating to the court that though you turned him in, your interests are not adverse to this respondent, correct?
Yes, correct. Sorry. I had to think about that. I apologize.
Okay, I'll pass the witness.
Ms. Smith,
Ms. Holland, do you live with your parents or on your own?
No, I live on my own. He just, during all of this that was happening, I did not want him around his younger siblings, and being a former addict, probably I think 20 years ago, that, that was bad for me and his little sisters. And so I told him he could not stay at my home. So he always runs to my parents' house because they let him do whatever he wants there. But that won't be an option. If y'all mandate that he has to stay with me, then he doesn't have an option to run over there.
Okay, so
I don't know how else to explain that.
no, sure. So you're telling the court that he will reside with you. This isn't a court order. That's not the reason he's with his parents. It's just because you wanted him out of the home during this time. But now you are telling the court that he will be with you.
Yes, because my concern too, we had robberies and we had, people showing up and all that, and they didn't know where my new house was. So that's, that was an issue. We were trying to eliminate all these problems that we've had.
Okay.
And his little sisters too were crying the minute he got home from rehab, thinking that those bad people were going to come to our new house. So.
Okay. And are you telling the court that whatever aftercare there may need to be after if he is sentenced to TYRC or ordered to go there, that you will help him get whatever services he may need, whatever probation may offer, or whatever is ordered by the judge in the future?
Oh, definitely. I mean, if he is willing to go and actually get in the vehicle with me, yes, of course. So a lot of this is on him too. I can only do so much,
Sure.
But I will find a way to get him wherever he needs to go.
Okay, I'll pass the witness.
redirect Ms. Craven.
Nothing further. Thank you.
May this witness be finally excused by both sides.
Yes, Your Honor.
Yes.
All right.
Yes, Your
Who would the respondent call as his next witness?
Honor. Respondent rests, Your Honor.
All right. Rebuttal, Ms. Smith.
Rest and close.
All right. Summation.
Your Honor, the state would just ask that you follow the agreement as set forth in the stipulation.
Ms. Craven.
Your Honor, respondent would ask that you follow the agreement as well in the stipulation and place him on probation until his 18th birthday. Help him by benefit of the county's resources to go to the TYRC campus to allow him to continue his drug rehab recovery after this last relapse, and put whatever terms of probation that are reasonable.
All right. Ms. Smith.
Nothing further.
All right. Mr. Holland.
Yes, sir.
First, I find that you are a child in need of rehabilitation. I further find that granting probation in this case is in your best interest as well as the best interest of the community.
Yes, sir.
You will be placed on probation until your 18th birthday. You must complete the TYRC inpatient program. You are to complete any recommended aftercare. Once you are released upon successful completion of TYRC, you will be equipped with a drug patch. Okay, If you use anything at all, we will know. And you will also submit to random UAs. You may not possess any real, replica, or play firearms and or air-propelled weapons. So that means no BB guns, no airsoft guns, no Nerf guns. Okay? You're gonna have 48 hours of community service to complete before your 18th birthday. I'm gonna waive any probation fees. I'm gonna waive any court cost.
Thank you.
I'm gonna waive any parental community work service because your mom has been so involved. And on top of this whole thing, I think she deserves credit for that. Upon release from TYRC, you will be equipped with an electronic monitor until such time as I decide or Judge Kim decides to release you from the electronic monitor. You will also participate in secondary schooling and or a GED program as a condition of your probation, okay?
Yes, sir.
You're too smart to get behind in your schooling. I honestly believe, just based on talking to you today and at our detention hearings in the past, that you could go on to college if you wanted to, but the first step in you getting there is you got to get your GED or your high school diploma. But I fully believe you are capable of doing that and doing really well. All right?
Yes, sir.
Anything else from either side?
No, Your Honor.
No, Your Honor.
All right, Mr. Holland, I do wish you good luck, okay?
Yes,
That'll
sir.
be the order of the court. Thank y'all.
Thank you, Your Honor. May we be dismissed?
Yes, ma'am. Thank you, Ms. Craven. I appreciate your hard work in this case. Mom,
Thank you.
thank you.
Thank you so much. Been a weight lifted off.
He's got to get there first. Baby steps.
I know, I'm
He's
praying.
gonna do it.
This is his last chance, so it's up to him now.
We're not going to give up on him. He's got it.
Thank you, Miss Craven. Y'all
Thank
have